In 1981, John Hinckley Jr. shot and almost killed then-President Ronald Reagan and critically wounded Press Secretary James Brady. He was only recently released from psychiatric care, but has spent absolutely no time in prison from committing those crimes. How is that possible? Today we're going to talk about the insanity defense. Welcome to Legal Briefs. I'm Attorney Jeremy Hogan. First, if you are insane, please don't watch this video. I don't want to aid or abet you in any crimes. For everyone else, the general rule in criminal law is that there must be an intent to commit a crime, what's called a mens rea, or the intent to commit the crime. And the insanity defense in general is that the person admits to having committed the crime physically, but because of a mental condition argues that they did not have the mens rea, or they could not have formed the intent to commit the crime because they did not know it was morally wrong. The modern insanity defense is based on a case from 1840 in Britain in which Daniel McNaughton was found not guilty by reason of insanity for shooting someone because he was not able to understand that what he was doing was wrong. He had voices in his head telling him to shoot the person and that it would be a good thing to do. From that point forward, the rule was called the McNaughton rule. Aside, legal rules are generally based on the defendant's name. So for example, your Miranda rights are based on a guy that was arrested named Ernesto Miranda. So if you want to be famous, get arrested and have it overturned on appeal. Though a common defense in most states, 4 states have done away with the insanity defense altogether by legislation. Those are Montana, Utah, Kansas, and Idaho, or you can refer to them by the handy acronym MUCKY. So if you are insane, do not commit a crime in one of the MUCKY states. It's not enough that the defendant simply testified to his insanity or her insanity. There must be medical evidence of the condition that the defendant suffers from. And even though there's medical evidence that someone may be insane or suffer from a medical condition, it is a jury issue of fact to decide whether the person knew or did not know of the wrongness of the action they committed. And juries don't like the insanity defense. It's only successful 25% of the time. If a person is found not guilty by reason of insanity, they are institutionalized at a mental hospital until the doctors deem them no longer a threat to society. And sometimes that could be longer than the prison term would be. And finally, although you usually see the insanity defense in connection with a murder charge, it's not limited to murder charges. You can use it for any crime. But don't use it at your speeding ticket hearing. People might think you're crazy.